joins in. Okay, I guess this is a good time to begin. Good afternoon, everyone. Thank you for joining us on a Friday afternoon. I hope you're not taking away or will not result in keeping you away from your evening plans for too long. But hopefully it's going to be worth it. We're going to take you through a traipse around the metaverse. We're going to give you an overview and an indication of all the laws that are involved. We're not going to give you concrete answers. What we're going to do is every chapter / law that we touch, we will pick up every month hereafter. So we will do a session next month on metaverse and intellectual property. We'll do a session the month after on metaverse and sports. We'll do a session on the metaverse and competition law, and we will do multiple sessions around that, including on privacy. So with that said, this is going to be our 4th presentation this month. Ironically, I made a presentation in real life on the metaverse, which was slightly ironical, but this is going to be our 4th presentation this month on the metaverse. Without too much ado, let me introduce the 2 lawyers who are going to take you through the issues. Aditya is a key player in our IP practice, not just the IP, but also IP. And so he's going to take you through a lot of the consumer / IP risks that arise in the metaverse. Adya, on the other hand, does a lot more work with artificial intelligence and data protection. So Adya is going to take you through a lot of that. And since both of them know far more than I do, I'm going to kind of keep quiet. On that note, Aditya, do you want to quickly introduce yourself and start the show?
Sure. Thanks, Matthew. Thank you all for joining us on this session. So to begin with, like Matthew said, we'd be taking you through various aspects. I think to begin with, maybe we'd give you a little bit of an introduction on what is the metaverse and what is its association probably with Web3. And this is something I'm sure that you would have all heard in passing or generally maybe amongst the younger generation. So the metaverse to begin with essentially is the sort of amalgamation, an oasis of sorts of various enabling technologies similar to AI, machine learning, blockchain, VR, AR. It's an amalgamation of all of this to create this virtual environment where people could essentially replicate themselves in the form of an avatar in the digital space. That essentially is what the metaverse is in a gist. But metaverse itself should not be confused with Web3. Now, for the uninitiated, in passing, when I had a conversation with my mom in terms of what I do in the tech space and what is Web3, I think the evolution in terms of what I'd explained to her, the evolution could be probably best expressed as what Web 1 was. So Web 1 was your usual HTML, click, you get into a website, the website's got information about your company, and that's about it. That was the nascent use case of Web 1. Web 2 was more of social media, interactions, an opportunity for companies also in terms of branding, an opportunity for people to interact with each other on a more personal level. Web 3 now is, I think, the next step, a collaboration of sorts amongst users and companies in this space. Everybody on this platform necessarily would be required to collaborate with each other to potentially result in this huge universe, digital universe, where people interact, there are branding exercises, at all. Now, from a Web3 metaverse perspective, so when we talk about Web3, like I said, it's essentially a difference between them. And the primary difference being the Web3 is the technology that's essentially blockchains, your NFTs, DeFis, which are decentralized finance, DAOs, which are decentralized autonomous organizations that essentially refer to this form of a decentralized internet where you aren't owned by just one entity. It's a collective, collaborative experience. The metaverse itself is the experience. The metaverse is the universe of the user as an avatar. This, of course, there are various characteristics of the metaverse. This, the fact that there's synchronicity, the fact that it's available to one and all. You have digital economies slowly blossoming off from this. And of course, probably the most important thing, that it's an interoperable space. Now, generally, like I said, the metaverse being this oasis of sorts of various enabling technologies. And I've had conversations with people where we've had arguments on, no, blockchain is the metaverse or AR, VR is the metaverse. And often people just throw Ready Player One as this, they brandish it as this random example of this is, and this is all that metaverse is, which isn't exactly true. Metaverse, as we envisage it, and it's how it's slowly evolving, is many things, and the use cases of which are probably even right now not known to us. 3 years down the line, where blockchain was digital ledger technology, people probably wouldn't have envisaged smart contracts and then the consequent development of NFTs. Similarly, you have AR and VR that's evolving at a pace that's probably unprecedented. You have Oculus, which has Oculus stores. You have various virtual worlds like Sandbox, Decentraland, where you can actually buy virtual property. 3 years ago, I would have said that's nonsense. Who's going to actually pay you money to buy digital land? That's something that's growing at a phenomenal pace. I think last year, close to 24 billion was spent on virtual digital assets. There's also ambient technology, artificial intelligence and machine learning, which probably plays a little bit more of a collaborative role in ensuring the persistence of the metaverse. But the real world implications is probably something that is, I think, over the past 2 years, you've really started feeling the effect of that. One probably interesting case, and it's a case that stunned me, but it's a case that I heard about very recently, was the fact that a couple in the United Kingdom filed for divorce because the wife alleged that the virtual digital avatar of her husband was cheating on her. So the impact of your virtual avatar, it's linked to your virtual personhood, is very real. And apart from its real world consequences, the ability of companies also to monetize this space is very real. Like I said, 54 billion worth of virtual goods were sold in the year 2020. Massive. Now, of course, you have, in terms of first mover advantage, you slowly start having companies that would seek patents. And now that's also another issue that we'll slowly move on to at a later stage when we do talk about intellectual property. But you now are seeing people register trademarks, patents, copyrights specifically for use cases in this space. You also have use cases where companies have started using the metaverse as this untapped branding experience. Now, what COVID actually taught us was that you could have interactions sitting in your home, probably in your boxes, with other people across the world. And those interactions are as good as you stepping out and talking to your neighbor. Probably piggybacking on that, you have companies that have realized the potential of platforms such as Sandbox, Axie Infinity, which are gaming space. Now, the gaming space is generally a low-hanging fruit. It's a domain that has a fair amount of capital. ready to be invested, and potential users. So they've always been probably at the forefront of technological innovation, be it AR, VR, and now as we see it with the blockchain. But you've got to give it to companies who have actually stepped up and actively started marketing themselves in the virtual space. Even universities haven't been too far off in terms of getting into the act. You have the University of Miami, which has recently started classes in the virtual world. Now, COVID taught us something in the fact that you really don't need to step out of your house. And you don't even as a company need to establish a physical presence. You have had virtual cities, for example. La Paz has a quite a apt example in this instance. There's this company called La Paz. What essentially they're trying to do is create a virtual city with land. They allocate land to companies as well to create showrooms where you would display your products for existing and future customers. And of course, fashion being something that's probably not too far away, you've had major brands like Forever 21 and Zara step into the act as well. Forever 21 and Zara, for example, have virtual showrooms where they sell clothes in the form of NFTs to your avatar and allow you to actually check the latest and the greatest on their online store, get a look and a feel for whether you like designs, and then decide whether you actually want to purchase that in the real physical store. You also have banks like HSBC and JP Morgan that have bought land in a sandbox. Now, while the banking application itself could be limited, what they probably aim to achieve is to give you as a user an experience, a banking experience that you probably never forget. You've also have companies like Honda that's very recently created a virtual showroom where the latest production line in terms of their cars can be tested out by your avatars, could possibly be bought maybe in the future in the form of an NFT. All of these are existing use cases of the metaverse. The governments also in certain jurisdictions have been too far behind. One probably, South Korea has always been at the pinnacle in terms of technological innovation and also their ability to maybe stretch boundaries. The Seoul metropolitan government is probably one of the first few governments in the world to establish a metaverse platform for public service. They call it the Metaverse Seoul. Basically as a mode of interaction for citizens and public servants, and to ensure that people in Seoul never feel disconnected with the government, irrespective of where they are from. You've also have other instances, for example, Barbados, which is a small island in the Caribbean, that's taken this one step further by signing an agreement with Decentraland, which is a popular metaverse platform, to set up an online embassy in Decentraland. These are instances that later on you'd probably see becoming more pervasive as time goes by, but would also address and result in major issues, for example, with regard to data privacy and cybersecurity. Adya, if you'd like to take it up in terms of the privacy issues.
Yeah, sure. So, right before this presentation started, Aditya and I were just discussing a couple of use cases, right, where we see data privacy and data protection concerns. I'll give you a couple of examples. In the US, recently, some reports emerged that there was a fitness instructor who, regular middle class, who was putting together money and trying to buy land on the metaverse. Specifically, this fitness instructor wanted to buy a piece of land on a real estate company that sells plots of land on the metaverse called Sandbox. What this person was trying to do was buy a plot of land that bordered a very famous celebrity, Snoop Dogg, for those of y'all who have heard, who is, one of these proponents of the metaverse and buying property on the metaverse. So this fitness instructor tried to buy a piece of land or a plot of land that bordered Snoop Dogg's property, so as to have some kind of exposure. This person had heard that there were going to be parties, there were going to be celebrities attending Snoop Dogg's virtual property on the metaverse. Another example was a nurse somewhere in New York who was trying to put together money, about $20,000, $30,000, to buy land again on the metaverse, using that as an investment opportunity to kickstart educational games and therapy games on the metaverse. What happened when each of these individuals tried to go ahead and actually purchase the land and entered their credentials, what they found was that it was a phishing scam, and hard-earned real-world money that they had saved for years disappeared in the blink of an eye. Another example, and I'm going somewhere with this, is if you go deep onto, Reddit threads and, people who engage with the metaverse, there was one interesting thread that I came across where an individual had posed a very serious question saying that I'm actually renting land on the metaverse right now. I'm renting an apartment, but my concern is that my neighbors on the metaverse can hear what I'm saying. Am I safe? Are there privacy controls I can implement to make sure that my neighboring tenants can't hear what I'm saying, or they can't spy on me? And there were a lot of responses to these questions. Specifically, a lot of people, clarified saying that since you're a tenant, you don't really have control over the privacy controls in your virtual apartment. What you need to do is actually buy the land. As a landowner, you'll be able to exercise more control and build in more security and privacy measures within your apartment on the metaverse. Now, these are two very, very different examples, but over the last couple of years, the kind of debates we've seen on data protection and privacy in the real, with respect to social media, with respect to big tech, are just getting amplified when you move that discussion to the metaverse. I would broadly categorize these concerns, into two different categories. The first one are the cybersecurity risks, and the other one are the data protection and privacy risks. When it comes to cybersecurity, all the vulnerabilities that we see with technology today exist within the metaverse, right? So your scams, your phishing scams get more sophisticated. Your ability to pretend to be another user become more sophisticated. Your simple things like even hardware vulnerabilities within your VR hands, your VR sets become greater issues when you engage with the metaverse. Let me go step by step, right? Over the last 2 years, what a lot of companies are recognizing is a high degree of vulnerability in the VR handsets or headsets that you use to engage within the metaverse. And what those vulnerabilities result in is a certain leakage of personally identifiable information. When it comes to within the metaverse as well, we are interacting with online avatars for all intents and purposes. I might be interacting in, say, an office setting with Aditya's avatar without actually being sure it's actually the real world Aditya controlling that avatar. So when we are talking about cybersecurity risks, you of course have your physical vulnerabilities that exist. You also have a very sophisticated ability to misappropriate identities, misappropriate people's trust. And what we are seeing, as for those of you all who are following the recent hacks that have occurred with cryptocurrency wallets, with NFTs, the scale just gets magnified when it comes to the metaverse. Those are the cybersecurity concerns. Another major concern that we see within the metaverse is the amount of data that is actually being processed. Do keep in mind that because it's an immersive environment that does involve a blending of your real world and the virtual world, there are a lot of your real world symptoms, for the lack of a better word, that are being captured. So for example, when I'm wearing a when I'm wearing the appropriate hardware to engage with the metaverse. Often it's my eye movements that are being tracked, my biometrics are being tracked. When my avatar is being created, my fingerprints, my iris scans, my face, pictures of my face are being captured. Even how I engage within the metaverse, right? How quickly my eyes move, in which direction. Are my eyes moving to certain types of stores, certain types of products or services? Every single piece of data is being cataloged. One, of course, to enable your avatar to move through the metaverse. That's one point. But the other specific point, and rightly so, just looking at the last couple of years of controversies about social media and big tech platforms, is that this data is also being cataloged and sold to advertisers. Right? So when we are talking about data collection practices, one of the major concerns that arises is, especially with respect to biometric data, how is that data being used? There are legitimate purposes for the use of this biometric data to ensure that the metaverse functions the way it's supposed to function, that your avatar can move around and reflect who you are within the real world. But a deeper question arises about what happens. Are there transparent processes about how the data is shared? If it's going to advertisers, are there checks and balances? Do we have transparent processes within the metaverse for you to consent to the fact or be aware of the fact that this data is being sold to advertisers? So what happens with the amount of data collection is that often individuals lose a fair degree of control over how their data is processed. So that's another major aspect of or concerns on data protection. A third argument that I saw arise, and I thought it was an interesting point, is that a lot of individuals argue that your traditional laws, such as the GDPR, don't apply within the metaverse, simply because the GDPR is based on the fact that you are processing personal data that is linked to an individual. There are questions about personhood that arise. So personal data about avatars does not qualify as personal data for the purposes of the GDPR. Now, that's an interesting argument. I don't think that will fly, because as long as data can link to a real world individual, real world laws apply to that processing. Right. So if you are collecting data about avatars, as long as can be linked to an individual in the real world, the GDPR or other data protection laws apply to you, which therefore means that the requirements of these laws apply within the metaverse. Things like seeking consent, making sure that as a person or as an organization that collects personal data about individuals, you spend or design systems that educate individuals about how their data is being collected. One major issue that we see is, and I'm sure all of y'all have experienced this while using the internet in general, is that there's a transparency process that is associated with data processing. When you use a service, as an organization, you're obliged to educate individuals to tell them that this is how we use the data, this is the purposes for which we use your data. Here, check out my privacy notice. In certain cases, especially when we're dealing with highly sensitive information, like your health data, like your biometrics, we need enhanced consent protocols. How does this translate to the metaverse? How do you build in processes? That's another question for which there are not really very, very clear answers. I know there are jurisdictional questions that arise about, does one country's law apply within the metaverse? Jurisdictions don't apply, therefore real world data protection laws don't apply. But I think there's a growing concern for the need for privacy by design principles, about designing systems in a manner where you try to minimize the purposes for which data can be used. Now, just looking at how the internet has evolved historically, there's a lot to be very concerned about. But it'll be interesting to see how these laws can be designed to ensure that we've got processes in place where there's an obligation on companies that collect data. There's an obligation on advertisers within the metaverse to ensure that they've complied with transparency and consent protocols. Aditya, any thoughts on that?
No, that's fairly interesting. Even in terms of like when we discussed on the aspect of tenancy on the real world on versus tenancy in the digital sphere, whether such ownership of digital land would in fact amount to your private space. All of these are actually fairly interesting questions that would eventually hopefully be dealt with. But it is an interesting space. So
maybe just as a little caveat, but there are more questions than there are answers today, right? We can speculate on what's possible within the metaverse, what's not, but I think there are more questions right now, and I'm not very sure about the answers, right? I think it's an evolving process. We will have to look to see how countries regulate it, what the precedents are, but definitely a lot to mull over.
true. So with that, I think maybe we could move on to the next bit with respect to intellectual property in the metaverse, to very large issues that are currently at play. From a branding perspective, like I said, the metaverse poses fairly interesting questions. Now, the metaverse in general, you've gotten to a situation right now where you've had brands like Nike, McDonald's applying for registration in classes that you'd probably never have expected them to register before. So class 9, class 35, it's deals specifically with the virtual world. Now, a hamburger company suddenly applying for a trademark under the classification of downloadable software is something that now it's become a reality. The same with Nike, that's probably introduced crypto kicks, which is a very new authentication system that they have right now in the form of NFTs for validating the authenticity of certain rare Nike boots that they do sell. Now, what actually the Web3 is probably addressed to a large extent from an IP perspective is probably the introduction of what's called the NFTs, or non-fungible tokens. So probably maybe as early as 5 years ago, rampant piracy was an issue that used to plague the digital sphere. There was no way to authenticate the originality of certain digital assets. If I had a song, for example, it was quite easy for someone to copy that song, distribute it on the platform, on any platform. In fact, if I was a photographer, if I took a picture, there's nothing to stop somebody else to copy that picture, claim it on some other platform as his own. What non-fungible tokens Web3 is gotten is this form of a certificate of authenticity attached to digital assets. That, along with the metaverse in general, has brought in a very different use case for brands on the metaverse. So you have, for example, right now, owners or users of trademarks, even in gaming spaces, that use third-party trademarks in video games, which simulate real worlds. These trademark owners would have to be slightly apprehensive right now, given the fact that this is not exactly there's no evolved jurisprudence on this matter, and courts, at least until now, have taken a fairly non-protective view in terms of the use of trademarks in the virtual space. One example that does pop in mind is that in a very popular gaming, in a popular game, Grand Theft Auto, GTA, where a strip club that was featured on the online version of Grand Theft Auto looked and had a very similar feel as that was there in the real world. what the judge during the hearing, what the judge felt it boiled down to from a trademark perspective was whether there was confusion amongst the users or customers. Trademark law in general, of course, the biggest issue that does pop up is likelihood of confusion. Given that this is a fairly old case before probably metaverse was as relevant as it is right now, but what the judge at that point in time felt was that a user on a gaming platform would in no way be confused with the digital version of that particular strip club, even if it looked fairly similar to that of the real world one, and accordingly held that there was no infringement. A similar situation also happened in the case of Lee Pellegrino versus Epic Games, where a fairly well-renowned saxophonist who went viral sued a really popular video game, Fortnite, which I'm sure if you've talked to probably your younger cousins or your children, you, they all talk about this. It's a fairly popular gaming platform that is in itself almost a metaverse. Fortnite started the allegation here was that there was a virtual avatar of the saxophone player, and the allegation was that there was a breach of his personality rights. The courts dismissed, unfortunately, Pellegrino's trademark claims and his right to personality, finding that it was actually better suited from a copyright perspective. The suit, of course, eventually was withdrawn by Pellegrino, but these are slightly troubling rulings by courts, probably because at the time in which these rulings were made, the virtual world wasn't as pervasive as it is right now. But it does amount to slightly troubling jurisprudence. And as we go ahead with the virtual world allowing us to create avatars, allowing users to create avatars, molding it as they wish to, you often may find a situation where you're either accidentally or on purpose, your avatar may look fairly similar to a very well recognized personality, for example, Amitabh Bachchan. So what's the liability of the user? What's the liability of the gaming platform? All of these are questions that may soon come before the court. But until then, there are a few best practices, at least from a trademark owner's perspective. To begin with, of course, assuming you do intend to enter into the metaverse, at least from a branding perspective, please ensure that you register yourself in all relevant classes. Keep a careful eye on other registrations for similar classes, and in the instance of infringement, immediately notify the infringing entity. From a copyright perspective, there are also issues in terms of licensing and policing copyright infringements, given that these are fairly common, at least as of right now, in the digital sphere. One under issue that we've often seen is in terms of when licensing agreements were entered into, especially for copyrights, pre-NFT, pre-metaverse. So while you may have, for example, the right to distribute and the right to publish, whether there was a specific right to distribute or publish your artwork on the virtual world instead of the in real life is something that could often crop up as issue and has cropped up as issues and is currently pending before the US district court right now. Given that at the time of signing and executing an agreement, the artist probably would not have intended to give you rights to use intellectual property in that particular way, this would always pose issues. So that's also something in terms of evolving jurisprudence that we'll probably have to see as and when it does come. In general, best practices dictate that you review your agreements in terms of distribution rights. You ensure that your copyright registrations as far as your API, your specific artworks are registered in your name to ensure that this does not get copied, or even in other ways, you have some form of evidence of creation and authorship. You also, apart from that, also have implications in terms of, like we discussed, personal digital persona or virtual personhood. Now, generally speaking, in the real world, as of right now, there exists a right of passing off from a personality right perspective, and commercial usage or representation of a particular person's image without his consent is often looked down upon by the court. Uh, but incidental usage in the form of an avatar or accidental usage of a person's likeliness, or maybe certain features of a particular well-known person by an avatar, is something that's probably not been dealt with till date. So that's something that we'll probably have to, I mean, as time goes by, we'll have to deal with, the courts will have to deal with. From a patenting perspective, of course, it's probably one of the most interesting areas in terms of IP, given that several jurisdictions around the world do not permit patents for softwares and algorithms per se, including India, and also several specific situations in the US where there is no technical effect. A patent for various inventions surrounding the metaverse uh, may be granted in a certain jurisdiction, but not be necessarily granted in others. Another probably interesting concept is with respect to artificial intelligence and the creation of certain intellectual property. Now, in general, what we have seen is that AI has reached the level where they could possibly create their own artwork with existing foundational data that's given to the AI. There have been instances where you've had AI create music of its own. Now, there are two questions that actually come from this. First is the question of authorship, and the others in terms of liability. Now, from an authorship perspective, of course, this is something that's probably been raised in multiple jurisdictions like Australia, Saudi Arabia, Japan, United States, where the question comes down to probably the amount of human intervention. Now, in general, we've seen jurisdictions being slightly hesitant to give authorship to artificial intelligence, given that they're not natural persons. But if you were to give authorship to the natural person responsible for that, the question that does come into play is human intervention. Now, what is the amount of human intervention in the AI creation of a song? Will the human intervention in the form of simply creating that AI itself be enough? Or is the human intervention, the level of human intervention require a slightly higher threshold, in the sense that me as a natural person, the data sets that I give to the AI has to be significant enough for the creation of that particular music, in terms of the underlying data sets that the AI would then use to create music. So these are questions that, again, remain slightly unanswered, but these are questions that have to be looked into and assessed. From a liability perspective, also, there are questions about in terms of the level of control that you do have as an AI, and your liability, especially from a vicarious standpoint, to the potential infringement of a third party's intellectual property by the artificial intelligence, either created by you or employed by you during your processes. So you could have a situation where you have a creator of artificial intelligence who's given preset data points to the AI to possibly create music, create balance sheets, a number of different things that they can do. you would then give as an author of the AI, you would then give that to another company, possibly to use it as part of its design development team or maybe sound production process. And because of the data sets that you had provided to the AI as a creator, uh, while being under the employ of the company or while designing that particular uh, design or music, if there is an infringement of a third party's intellectual property, who is liable is a question that has yet to be answered. Um, Again, from a licensing perspective, what you should be very, very aware of is the aspects of territoriality. What exactly are the rights that you grant? For example, you could grant the right to distribute, but not the right to publish. You could grant rights for both. Uh, you even in terms of the services and the devices and the different use cases, uh, the rights granted could vary from something close to unlimited to a very narrow right in terms of licensing of intellectual property. Now, another question that often keeps popping up is a question of ownership. Now, I've had this discussion with a colleague of mine on multiple occasions where his argument and the argument that he kept pushing was, do I actually own anything in the metaverse, or is it in effect a license granted by the platform owner to use? Again, with the advent of NFT and with several rulings in the UK as well as Singapore that NFT does amount to property, this would be something that would probably require analysis of the terms and condition of the platform itself, as well as assuming you are buying an NFT or a digital asset, the terms and conditions attached to your smart contract or the terms and conditions attached to your to the terms that you provide the NFTs with. Now, moving on from probably the IP bits, a secondary question does arise, and that's one of jurisdiction. Now, traditionally speaking, intellectual property has the jurisprudence has evolved to a situation where you have courts that have held that as long as cause of action arises within the jurisdiction of the relevant court, that court has jurisdiction to deal with the dispute. So, for example, as of right now, we have instances where you could have a hotel based out of, say, Thailand that allows you to book it in India. Now, if that particular hotel infringes the trademarks of your hotel based out of India, as long as it allows people in India to book rooms within India itself, that vests jurisdiction for the court in India. Similarly, you would possibly now with potential use cases as far as NFTs and smart contracts and old concepts such as territoriality, boundaries, sovereign states exerting control over citizens slowly melded away with the metaverse. You could see existing jurisprudence being pushed to its limit, especially with the advent of smart contracts being the basis of your purchase of NFTs, which is now could potentially be qualified as property. The Indian government, as such, has said that it has no plans to regulate the metaverse, given its nascent nature and given that this is still evolving. However, the uncertainty does not really benefit persons or entities that do look to trade within the metaverse. Apart from that, of course, you have issues from a criminal liability perspective, where you have, for example, very recently, a woman based out of London alleging gang rape of her metaverse avatar. Now, given the intricate nature in terms of the link between you and your virtual persona, going forward, you would possibly, it's very foreseeable that going forward that you would possibly have situations where actions committed in the metaverse could result in real world trauma to individuals. Now, what is the extent, given that, of course, especially for criminal actions, you do end up registering complaints against people, and the police or the enforcement authorities are often restricted to their relevant jurisdictions. The pervasive and international nature of the metaverse could potentially have a large impact on how such criminal complaints are dealt with. Even from a workplace, especially from the Prevention of Sexual Harassment Act's perspective, while jurisprudence has evolved now to term workplace not merely restricted to your physical workplace, you would have to consider the fact that you could have people residing in multiple different jurisdictions. You could also, like Adya pointed out, have a situation where if me and Adya were interacting, if there could be a situation where my avatar may not have been necessarily controlled by me. So implications as far as actions conducted by my avatar and the liability being imputed to me is something that possibly would have to be dealt with from a criminal perspective. So that's as far as your criminal civil liability is concerned. Another interesting aspect, of course, is that of your competition and antitrust laws. Now, from an antitrust perspective, like I said to begin with, your metaverse itself is underpinned by the fact that this is a collaborative environment, a collaborative creation of digital environments. Now, in this situation, it's very possible that large companies will likely face antitrust securities, not only because of the level of influence that they have in this sphere, but also given the fact that they have so much pre-existing access to users' personal data, their resources, and also the fact that they, being the size that they are right now, could potentially look at a situation where larger companies end up acquiring smaller companies, thereby creating what's called a barrier to entry. You could also see larger companies potentially create specific restrictions to downstream content providers by specifying that users, for example, can use only specific gateways to access the metaverse. You could also have situations where players in the metaverse, or even companies that do join the metaverse to be a part of this collaborative process, can only use specific payment processors in order to transact within that specific platform. And these are, in fact, issues that are currently ongoing, at least from the App Store, Play Store perspective, in terms of necessarily requiring certain payments to be routed to specific ways. And of course, given the fact that there is almost no competition, whether you would force players within the market to align to your specific requirements, thereby creating monetizing opportunities only to yourself. You also have a situation where you could have digital source, where developers offer their applications to be subjected to specific fees or mode of payments that are unilaterally accepted. All of this could very potentially result into major competition and antitrust law issues in the metaverse, and ought to be considered in terms of your planning and from a business perspective. Adya, would you like to pipe in a little bit in terms of?
No, I think the major issue here, like we discussed, right, is that the advent of the metaverse raises more questions at a rate that's faster than it is to answer such questions. There's obviously a lot that is still in the pipeline. I think every month we see new case studies, we see new examples, we see new situations that have certain legal implications. But yeah, it's going to be a very interesting space to watch.
Indeed.
Any questions? Anything that we can, I think.
I think Aman's raised a fairly interesting question. So essentially what Aman's saying, suppose person A makes a movie and assigns all rights for broadcasting on an OTT platform, taking into account Section 18 of the Copyright Act. That knows. Okay, so Aman's question essentially, I think, deals with, I think Aman's 19 of the Copyright Act. Okay, no, 18 of the Copyright Act in terms of mode of execution. Would we need also have? Okay, I think Aman's question, I think, primarily forms around the fact of contributory infringement in terms of whether the Metaverse platform could potentially be liable in case of an infringement for an unauthorized broadcasting. From a contributory infringement perspective, I think what's the most important, of course, Aman, is actual knowledge. Now, generally, what the IT Act and what Section 79 does provide for you is a safe harbor for what users of your platform do or perform on your space. In general, as long as there cannot be any imputation of knowledge, and this would also, of course, require the platform to have active takedown notices and policies in place. But assuming you cannot impute actual knowledge, you generally would be covered from any potential liability. Matthew, would you like to add anything?
No, that is absolutely correct. As long as you keep within the rules, and as long as you don't go and do anything that encourages any infringing activity, I think the possibility that any non-primary active act player be found liable for contributory infringement will be negligible. Does that help?
I assume it does, given that Aman doesn't have any additional questions. Does anyone else have any other questions that we'd probably be able to address?
Have you answered? Yeah, okay. Have you answered Urvi's question?
I do not think so.
Okay, so the question that's come up is whether there's a need to divide the transition from Web3 and Metaverse, or whether it's kind of a continuum. Urvi, it is a continuum in terms of technology. The question of liability and other legal issues will be similar. However, like Web2, like Web3 indicates a jump over Web2, the Metaverse indicates a technological jump over Web3. And therefore, the complexities involved in the questions significantly compound, right? So if you looked at Web 1, and I don't know how many of you were younger than 1 or 2 years old at that time, but when you look at the first phase of the internet, questions around liability primarily involved theft of copyright, right? And simpliciter theft of code, right? Nothing major. Went on to look and feel. Web 2 brought in far more complicated questions of copyright, but also of patent and trademark infringement. Web 3 took all of this and brought in questions of liability and consumer protection law into all of this. I think the metaverse will compound all of these, right? And so, is it a continuum? Yes, it is. Can we see a trend? Yes, we can. What's the trend? Everything's getting more complicated and interesting for lawyers. That's the broad trend. You'll have to scratch through. And that leads me to Anmol's question, which is what kind of work will Metaverse raise? I think there will be issues around intellectual property. There will be issues around liability for artificial intelligence. There will be issues around liability for the actions of online personas. There will be general privacy related issues in data protection. There will be complicated questions around jurisdiction. And I can tell you that, barring maybe tech lawyers, the vast majority of lawyers right now would find it very difficult to answer all of these, including Aditya, me, and Adya. And therefore, we will look to a new generation of extremely young, smart lawyers who will probably make many of us redundant. So it may not be avatars or machines that make us redundant. It may just be many young lawyers who understand these concepts a lot better. Shishir wants to know how one would tackle the question of artistic freedom as provided by the First Amendment. So I don't think in India there is any First Amendment, but I'm guessing you're talking about the United States Constitution, and about a judge allowing intellectual property rights infringement of a strip club in the ESS entertainment case. And it raises a problem, Shishir. Your question indicates one of the problems that we have, which is when you try applying concepts that are foreign to an Indian law, and you assume that I would know what the ESS entertainment case is. And I could fathom what a judge would look at looking at IP infringement in a strip club. Let me tell you, after 20 odd years here, that no Indian judges looked at IPR infringement in a strip club. And one of the questions that the Metaverse, and I say this in a, slightly in jest, but one of the questions that you will fight across very clearly with the Metaverse is which law applies, right? But that said, Aditya, do you want to take this? Do we know what the ESS entertainment IPR infringement in a strip club case is?
Yep.
Do you want to take this?
So, I think foundationally speaking, Anmol, honestly, this particular judgment, like I said previously, was at a time where probably the Metaverse wasn't as relevant as it is right now. So the conflicting questions before the judge at that point in time was A, of course, freedom, artistic freedom, and B, likelihood of confusion. Now, at that point in time, and like much of us older lawyers, the assumption was that any user in a game would honestly never be confused of the source of origin, and that's the foundation of all trademark law. The source of your goods or services, especially if there is if there is similarities between what's being offered on that particular game and users who would potentially be deceived in terms of origin to the real world strip club. That I don't think would be as applicable right now, given how almost every other kid seems to be on the Metaverse, on their individual. So you have Roblox, which is the Metaverse of itself. You have Sandbox, you have Fortnite, each of which are their own individual little Metaverses. So with businesses actively coming onto such platforms, you have, for example, like I said, HSBC that owns its own plot of land on Decentraland. Same with JP Morgan. You have Forever 21. You have Zara that has entered the Metaverse. The question of likelihood of confusion right now exists. So I don't think this particular judgment's aged that well. That's my simplicity answer.
Okay, perfect. Any more questions? I'm guessing not. So very quickly, thank you everyone. Like I said, this was us laying the groundwork for a multi-series video conference on multiple issues in the Metaverse. We'd be glad to have you all on joining us for future sessions. I think we'd be doing 2 in the month of June. One would be fundraising challenges for startups that focus on the Metaverse. So what are the legal and regulatory issues that venture capital funds would look at while looking at the metaverse. And the second, towards the end of the month, will be on intellectual property rights in the metaverse, where again, led by Aditya and probably one other colleague from our intellectual property team, we'll do a deep dive on the many issues, patent, copyright and trademark and confidential information issues that could arise in the metaverse, including things that could arise at the confluence of artificial intelligence and metaverse, including questions around attribution, ownership, etc. So I look forward to seeing all of you back in a couple of weeks. And on that note, I hope you all had a little bit of fun today. Thank you.
Thank you.
Bye-bye.